Welcome here, everybody. Hope you're enjoying your lunch. We're doing a pretty informal conversation and workshop on employment law today. My name is Bryn Rieger. I'm from the Ontario Justice Education. We're doing different types of workshops and presentations. We just did like a navigating police encounters session with the high school this morning, and basically where I'm from, Ontario Justice Education Network, we're a bunch of lawyers and teachers who work in public legal education. So we don't have clients. We don't interpret the law to try to make arguments before any courts, but we look at the law to try to make it accessible for people. So that's kind of our mandate. And this is part of that. So discussing employment law, we're taking a look at like the black letter law, those really like hard to read, inaccessible materials in the forms of like bills or statutes, and we look at them and we try to interpret them for people to give plain language understandings of like what they actually say. So some laws are better than others. Some laws are written in language that is plain. Some are not written in plain language at all. They're written in legalese, basically. We have a mixture of those here in Nunavut as well. We're going to get into the specific laws that cover employment in this session. So I'm going to speak a little bit about some of the basics of employment law, mostly from an employee perspective. So what it looks like to have a good employer, somebody who's following the law, somebody who creates a good workplace environment. And then I'm going to pass things over to Abdullah. Maybe do you want to just intro yourself for a sec?
Yeah, my name's Abdullah. I work at the Legal Aid Clinic in Rankin. I'm a civil lawyer, so we do housing, employment law, human rights, and occasionally police misconduct work. And usually we do employment law, but from the side of the employee.
And then
they'll flip it over to me. I'll be discussing workplace harassment and the aspects involved in a workplace investigation. So what your employer should have in place, as well as the process on what is looked at when we're conducting a workplace investigation. So kind of the best practices. I actually work with the Law Society of Nunavut. I support them, and I do conduct workplace investigations.
Great. So can I just we can go to the next slide, but can I just take a brief survey? Like, why are people here to learn about which side of things, like employee side of things, employer side of things?
Employee side.
Employee side of things. What about you?
Employee and employee.
Both.
Employer.
Okay, got you. What? Both. And you as well? Okay. That's good to know. So we'll cover all of it in this session, but yeah. So this is a combination of both workplace safety and the law governing employment. We'll just go to the next slide. Can I just get a show of hands, like who knows nothing about employment law, legal rights around employment law? It's okay if you know nothing about it. That's better, actually. Okay, you? Who knows very little? Okay, a few very littles, including Francois. Francois is also here from the Law Society. I think, who knows some? Like 3, like middle. Okay, most people 0 or very little. Does anybody know quite a lot or a lot about employment law? Rebecca, okay, got one. Okay, that's good to know where everybody's at. We can go to the next slide. Just by way of introduction, what is employment law? It covers the relationship between an individual and their employer, and it protects workers from exploitation, discrimination, and harassment from employers. So it's obvious to a lot why employment law is really important. Sometimes we look at the law, and especially from like my line of work, a lot of people are really interested in the criminal law, right? It's what you see most on TV. It's what you see like most in the media. It's what we generally have the most information on in terms of the law. But criminal law is actually a pretty small percentage of legal issues people will encounter in their life. And nearly everybody will encounter issues of employment law in their lives. So it's really important from us as an organization to be focusing on employment law. It's the most common area of the law that people will actually engage with in their lives. Hi, welcome here. You can come on in. There's lunch right at the back. We're just doing a session on employment law. Hi, welcome here. It's for anybody. Go ahead. So one of the things that we talk about when we talk about employment law is the Labor Standards Act. And this is the kind of, remember I talked about the boring kind of inaccessible law before? Well, this is it. So this is like, this is what governs minimum standards for employees in Ontario workplaces. So the very minimum that an employer has to do to be able to make their workplace a safe workplace. So this includes the payment of wages, how much you get paid, right? Public holidays. Something a lot of people don't know is that public holidays are actually included in the law. They're written down in the law. So if everybody else is getting a public holiday and your employer isn't giving it to you, you actually can look in this law, in this Labor Standards Act, and see it's actually written down there to show that this is a public holiday. I should have this day off. Okay. And Abdullah will get a little bit more into some of the details of like wrongful dismissal over this kind of stuff. But for now, we'll just cover the basics. Your hours of work, how much an employer can actually expect you to work. Hey, welcome here. You can come on in and get some food. Overtime pay. Overtime is really important to know about. It varies from province to territory. Here, overtime pay, it's actually also in the law. Vacation time, statutory leaves, termination. So termination is when you're fired, right? And what the law is around how you can be fired, when you can be fired, how much notice you have to be given. This is all in this one document, this one Labor Standards Act. So honestly, if there's one thing that I want you to take away from this presentation, from my perspective, it's this Labor Standards Act. And you can go online and look it up. Just search, you can just Google Labor Standards Act on Google. And if you have the skills enough, you can just do a Control F search and search like wages, holidays, hours of work, and that will come up in the government's page for the Labor Standards Act. Yeah. So most employees are covered by the Labor Standards Act, and most young workers are also covered. A lot of people think if they're young people and they're working, that they're not covered by the same thing with adults. So how it works in criminal law is there's a different set of rules for people who are adults and a different set of rules for people who are young people. That's not the same when it comes to the Labor Standards Act. It applies to all workers, okay? So does the Labor Standards Act cover overtime pay? What does everybody think? Yes? Yes? Yes, it does. So when does overtime pay kick in? Like how many hours do you have to have worked for overtime pay to kick in? Yeah.
After the regular, yeah.
After the regular hours. So 40 hours a week, right? Like in other areas of the country, in Ontario, for instance, it has to be 44. So you work 44 hours before your overtime pay actually kicks in. I think there's a lot of advocacy being done to get that down to 40 by advocacy groups in different provinces, but in Nunavut here, it's 40 hours, which is good. So that's when your overtime pay kicks in. Go. Did you have a question? No. So if it's more than 40 hours, you should be getting paid overtime. So if your employer is not paying you overtime pay after you've already worked 40 hours that week, that's when you're going to want to make a complaint. And Abdullah is going to get into some of the details around that stuff, right?
A little bit, yeah.
A little bit. But the general rule is that an employee, right? So you work for somebody, you're their employee. You can take 1.5 hours of paid time off work for each hour of overtime that's worked. Does that make sense to everybody? Does everybody understand that? Yeah. An employee can take 1.5 hours of paid time off work for each hour of overtime worked. So if you're at say you've worked 40 hours in 1 week and you're on your 41st hour, you can actually, you should actually be paid an hour and a half for that 1 hour that you worked, if it's above that limit. Does that make sense? Okay. And again, if you have any questions about this and you don't feel like speaking up in the group, you can come to Abdullah or any of us after and we can talk about it. What is the minimum wage in Nunavut? Does anybody know what the lowest that you're legally allowed to be paid is in Nunavut? We have two answers here, 15, 25 or $19. You're thinking A?
You think it-
You think it's
Is
B?
it? I think it's. Is there a winner? Except for a draw?
Oh, did we?
What is it?
Wait, what is it? Oh, well, I know what it is. It's 19. We actually didn't have we must have skipped the slide where we say 19 is the winner. But it is 19. It's higher than in a lot of provinces, but that also, and it's higher than both the other territories, but that has to do, that's calculated by the government really specifically. So 19 makes sense for the amount that we all paid for these sandwiches today,
Yeah.
for instance. Yeah, exactly. And there's lots of reasons for that, but it's good to know that if your employer is offering you a salary of less than $19, that's not legal, right? So do we think that young workers are entitled to a lunch break or coffee break in their workday? Remember, young workers. So let's say 18 and under. Or sorry, I meant to say under 18. Do we think they are entitled to a lunch break or coffee break? Okay, it was a trick question. You got me. It was a trick question. Yes, of course they are. So this is something that we get with young people a lot, actually, is that like especially in the restaurant industry, people are often illegally deprived of breaks, right? They say, well, you're working through there's lots of customers. How can we let you have a break? And this happens all the time. Just like nurses. No, it happens in lots of professions, right? So, but according to the law, you may not work longer than 5 hours in a row without getting a 30-minute eating period, right? So if your employer is trying to say, we actually just need you for like another 6 hours, it's really busy, can you just do us a favor and hang on? That's illegal, right? And that's not a safe workplace. So this is not something that's up for debate. It's not something that one employer can say over another employer. This is something that's actually written down in the law, right? So it's not you being like fussy or not being a good worker or a hard worker if you're trying to say, I deserve a lunch break. It's something that's actually written down in the law. How about this? This is a little trickier. Can an employer ask you if you have a criminal record on a job application if you've ever been convicted of a crime? So you think they can?
Yeah.
Everybody agree with that? Yeah, everybody agrees. So the answer is it depends.
Yeah. It's in the word.
So, but an employer in general can ask you for if you have a criminal record, but a lot of people don't know the difference between a criminal record and being convicted of or being found guilty, not convicted of something when you were a young person. So again, this is if you're under 18 and you're found guilty of a crime, that's not an actual adult conviction. Remember earlier we talked about the difference between an adult system in criminal law and the youth system in criminal law. That actually makes a difference in employment when it comes to whether you can actually answer no to having a criminal record. If you were found guilty of a crime when you were under 18, according to the Youth Criminal Justice Act, you can actually say no if an employer asks you if you have a criminal record. So that's good to know for somebody who maybe got in trouble when they were younger or like had some run-ins with the law, but then as an adult has no criminal record. You can actually honestly answer and be telling the truth. No, I do not have a criminal record if that was before you were 18. Okay. Just before I pass things over to Abdullah, I want to note some traits of a good employer. So a good employer must keep detailed records of hours worked, wages, and deductions. If you ask your employer for records of these things and they don't have them, That's not legal, right? That's cause for a complaint. They must give their employees a pay stub or a pay slip with each pay. So every time you get paid, you should be able to see how much you were paid and a breakdown of that. It should be a regular pay period and payday, right? So it shouldn't be like, oh, we paid you every 2 weeks. Now we're paying you every month and a half. If those pay periods are irregular, that's also against the law, right? They also have to give 2 weeks notice before terminating an employee. So they can't just send you home right away without making up for that. They have to give you those 2 weeks. So if you're ever fired from a job and you don't get those 2 weeks, that's when you're gonna want to go to legal aid or the Law Society, and they're going to refer you to a lawyer to help fight that. Okay. And yeah, go ahead.
Shifts or something in.
So there are different amounts of how much time you've had to have worked to be able to get that 2 weeks. I believe it's 3 months, right? Abdullah?
Usually a
Yeah.
probation.
Probationary period of 3 months. And with that, I think, we have, okay. Oh, I gave you did anybody see the answer? Okay. So this is from the employer side of things, just for the last couple questions. One of my workers is refusing to do their job because they say it's unsafe, but they can't complain because other people do the same job all the time with no problems. Do we think this is true or false? Do we think it's true that they can't complain or false that they can't complain? We think it's false? You're all right. Okay, good. So because you're refusing to do a job that's unsafe, doesn't mean you can be fired for that, right? That's your legal right as an employee. Okay, so before we actually go to the workplace safety and harassment section of this presentation, I'm just going to pass things over to Abdullah, who actually works in this area and can provide a little bit of information on wrongful dismissals. So when you're getting, when you think you've been fired wrongfully.
Yeah, thanks so much. So
Oh, go ahead first. Yes, of course.
Public politics, we have the right to do. We don't need to go on ways.
Yeah.
But what if it's a Canada and we're working in this town that they're saving it. Our main office is in Winnipeg, but we're working here in the Hamilton, like the community has half the day off.
Right. Abdullah, have you had clients with that problem before?
I haven't had clients with that problem before, but there's a definition of the act for statutory holidays that are covered. If it's a holiday that's given by the municipality, I don't believe it's covered under the same provisions as the act lays out. I'd have to double check that though. So don't take my word for it yet. come into the legal aid clinic and we'll confirm it.
Another good disclaimer is that we can't provide legal advice today. We can only provide legal information. But if you talk to Abdullah and come into the office about a specific situation, then they can actually set you up with a lawyer and be able to provide legal advice at that time.
It up for a client. It's covered by that. There's a bunch of other things that if an organization choose to cover, but if we're not in the it's chosen.
Did you want to?
Really have a screen time holiday. Community.
Yeah.
Yeah, that's pretty standard across the board. So a lot of the times there is the statutory holidays, which are off, but in a bunch of different provinces as well, they may have civic holidays, which are not necessarily given off by every employer. So it's likely the same as what Francois is saying in Nunavut.
Yeah, thanks so much. So on the topic of wrongful dismissal, so a wrongful dismissal is when an employee is terminated. Generally, this occurs is when they're terminated without cause and they don't receive a reasonable notice and they don't receive any severance pay. So there's two types of termination that can occur generally. There's termination with cause, and that happens if the employee, is terminated because of like fraud or theft, or they're absent a lot from work, and there's grounds that they can be terminated and with cause, of course. They can also be due to a breach of company policy. And in those instances, the employer doesn't necessarily have to provide payment, and they don't have to provide notice. So they can just say you're terminated, right? So just generally, what is notice? Notice is just the advanced notice of the termination date that you have. So normally, I think the minimum under the act is 2 weeks, but as we spoke about before, it's also varies on if you have a probationary period, and those probationary periods can range in length as well. So it's very important to not only understand the act, but understand the individual employment agreement that you have and keep a copy of it. A lot of the times we have clients come in, we want to help them out, and they have like an offer letter, and we know the rights under the act, but we're missing a lot of documents in terms of the actual employment agreement. If you can retain a copy of that in any employment scenario, it's always good to have your own signed copy of what you sign. That's my little public service announcement. So the other type of termination occurs where there's termination without cause. So without cause termination can happen if there's sort of like restructuring in the company, or there might be poor work performance. And normally what will happen, an employer will just come up to you and say, look, we decided to terminate you without cause. They'll sign a termination agreement, and you just weren't a good fit for our company. That's what they'll say. So they don't have to give you a reason if they're terminating you without cause. If you're terminated with cause, there does have to be a reason, right? There has to be cause. Pretty self-explanatory. So
And just can I give the like plain language like interpretation of those terms is also like termination with cause being like you're being fired for a reason, right? An apparent reason. Termination without cause, you're being fired. Well, I don't suppose there's still a reason, but it's
it's more of like an internal reason.
An internal reason.
It could be like it could be poor work performance. That's another example, or there's a shortage of work in the organization and they have to let you go. So it'll say without cause. So when you're terminated without cause, there's a requirement that you receive notice. So the employer has to give you that date, that window of, okay, you've worked with us for a year, you're past the probationary period. There's 2 weeks of notice that we're giving you, and then on that date you're terminated and you're no longer working for us. Now, if you've been working for someone for a longer period of time, or you have very specialized role within the company, then that period can increase. And the reason why that's important is, one, you as an employer get more of a notice period to kind of readjust, search for another job, get your own affairs in order. The other part of that is the employer can opt to terminate you with pay in lieu of notice. And what that means is they'll pay you an amount instead of giving you the notice period. And the amount that they'll pay you will be equivalent to a calculation based on the time that you had for notice. So for example, if it was a 3-week notice period that they were giving you, and say you're entitled to 3 weeks of notice, we're going to give you an amount of money equivalent to you working that amount of time that you would have normally worked over those 3 weeks, but you're terminated today.
So they're saying you're going home today, you're not coming back, but you get this.
But you get this amount of money. So this is where a lot of complication arises, because oftentimes you're presented with a termination agreement. So the question becomes, well, what happens if you don't sign the agreement? Your employer says, we're terminating you, and you go, well, I don't agree with how you've treated me, and I don't think you're terminating me for the right reasons, and there's something going on behind the scenes. I don't want to sign this. I don't want to get involved with this. You're still entitled to the minimum standards under the act, even if you don't sign that agreement. So you're always entitled to standards in the act, whatever the minimum standards are. And the reason why you wouldn't sign that agreement necessarily is because you might actually be entitled to even more than what the act lays out, right? So the act is going to say, 2 weeks notice, and then they'll give you a calculation based on how long you've worked with the employer. But there's also a bunch of other legal principles that get pretty complex in trying to determine how much a person's owed in severance pay when they're fired or terminated. And so a couple of things that we take into consideration is how long you've been working at the role in the same position, and then as I mentioned this before, how specialized your role is, what type of work you're doing, what's the characteristics of the work that you're doing and the nature of the employment. And then what's the possibility to find opportunities that are similar level in the role that you previously occupied once you're terminated. That's a big deal in Nunavut in general, because a lot of the jobs, if you're terminated, it's very difficult to find a similar role in a similar position in the community that you're in or in other communities. So that's something to keep in mind, and that's part of the assessment that we do when we have employees come to the legal aid clinic and we do sort of a legal analysis. So my pitch to you guys is, even if you're an employer, what we do is we do a lot of representative actions for employees. That's our focus. That's what under our statute as the legal aid in Nunavut, that's what we focus on. However, if you're an employer and you have general legal questions and you're worried about compliance, I can't give you legal advice, but I can help refer you out to lawyers that can answer your questions. Or if you are involved in a civil claim, I can refer you to lawyers that would be able to help you. And then I can also provide just general legal knowledge based on sort of what's under the act and what we know. So again, I can't provide any legal advice if you're an employer coming in, but I can refer you out. So if you have questions and you're in that position, don't hesitate to come in. It's better to have guidance on the sort of stuff than run afoul of it in the future. So, and of course, if you're an employee and you have issues, come in, we'll help you out.
Great. So I think with that, I'll pass things over to you.
So before we get started, how much do you guys know about workplace safety and harassment? A fair bit.
Yeah. Courses in Winnipeg through the Manitoba Nurses Union,
Okay.
bullying, and that's
Perfect.
pretty familiar. And even up here in Nunavut, I know there's a process to go through, but it's very painful. You have to go through that, walk through that process if you're being bullied, right?
Yeah.
I think a lot of, I know nurses, they just can't be bothered because of it's huge. I've been through it in Manitoba too, and it's, quite the process.
Yeah, so I'm actually going to go over a little bit of what happens during a workplace investigation, so that you guys have an idea, and a little bit about what your employer should have in place for a workplace investigation.
So you mentioned that it can be a painful process, it can be a difficult process, and a lot of that is, unfortunately, this onus kind of gets put on
Yes.
the employee to have to
Exactly.
do this. But we're going to go through a few things that to maybe hopefully make it a little less painful if you know your rights around this stuff, that it's not, catching you off guard or a surprise to you.
Yeah. So in terms of legislation, workplace harassment is defined by the Occupational Health and Safety Act as engaging in a course of vexatious comments or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. So in terms of that, it is a pattern of events, whether it be comments, conduct, that makes you uncomfortable, and the person needs to have known that it would make you uncomfortable or be aware that it would make you uncomfortable. So in terms of that, we're not looking essentially at the intention behind the individual's actions, but if you have made them aware previously, I'm uncomfortable with this, or your body language dictates that you're uncomfortable with this, this could be considered harassment under OSHA. So in terms of the most common workplace investigations, we usually see this based on discrimination, harassment and bullying, sexual harassment, employee conduct and behavior, workplace violence, employee performance, fraud and theft, and breach of policy, rule, and legislation. So for the purpose of this, we are going to be focusing on workplace harassment. So in terms of workplace harassment, there is a few that are included in the definition. There's physical harassment, unwanted physical contact, assault, or other physical actions that cause harm or fear. Verbal harassment, name calling, insults, and offensive comments, including those related to gender, race, religion, sexual orientation, or other protected characteristics. Psychological harassment, repeated behavior or comments that undermine an employee's confidence or self-esteem, such as yelling, belittling, or intimidation. And sexual harassment, which is any unwanted sexual behavior, advances, requests, comments, gestures, or physical contact. Does anyone have any questions before I move on?
It's interesting that that kind of definition of psychological harassment undermine an employee's confidence or self-esteem. A lot of people might not necessarily associate that with harassment, but it's a really real and common problem in the workplace, right?
So in terms of your rights, if you are experiencing any form of harassment, it can be solved through an organization or community through a workplace investigation or by filing a complaint with the Human Rights Tribunal. So you are able to bring up a complaint either with your appropriate personnel in your organization and indicate that you'd like a workplace investigation to occur and you are making a complaint of harassment, or by filing a complaint with the Human Rights Tribunal. So when should an investigation be conducted? When we're looking at this, OSHA actually indicates that any employer who receives a complaint or there is an incident has a duty to investigate. So anytime a complaint is brought forth to an employer, they have a duty to investigate. So that's something, whether, as you can see on the screen, it's someone files a complaint, if someone observes inappropriate conduct, if there's an allegation or behavior that could be true of harassment, or if there's any serious allegation as well. So as an employee, you do have a right to be provided with a workplace that is free of harassment. And so it does go on everybody in the workplace to ensure that that occurs, but it is your employer's duty to ensure that you are working in an environment that is free of harassment. Another key thing is that workplace harassment includes any incidents that may arise at the work site during work hours, between workers, anyone in the workforce, so that's employers or other employees. And additionally, it also includes interactions with contractors, visitors, customers as well. Additionally, incidents that take place outside of the work site and are after hours but are connected to the worker's employment also fall under this. For example, a holiday party or a conference. So if you experience harassment outside of the workplace, but it is related to a workplace event, you can still file a complaint of harassment. In addition, OSHA is actually changing the definition of harassment to include and extend it to virtual and online as well. So if you are working remotely and you're experiencing any form of harassment via social media, via your Teams or Zoom, or any type of online situation, that also is included in the harassment definition, and you can file a complaint. So
So,
In-
what if they,
sorry, could you speak up?
what if they say you're not?
So we would have to look at and conduct an investigation to determine if it is a pattern of behavior. So if a comment like that is made and it's consistently made and you've indicated that you're not comfortable with this, again, there would have to be an investigation. So I can't say yes or no, but we would look into that situation.
But you're right to point that out, as that seems to fit. We can't provide legal advice here. We can only provide information, but what you're talking about, like, you're not from here, seems like it fits that kind of definition of trying to undermine your confidence, right?
Or it could be related to discriminatory practices. Again, we would have to
Yeah.
look at all of the information, and I'll go into a little bit about what an investigation process looks like. But if you are feeling any type of concern or concerning behavior, then we would recommend that you can submit a complaint and an investigation could be conducted. You can also go speak to legal aid as well, and they'll be able to assist and provide more information. All right, so in terms of the process, a workplace investigation does follow a process. So it starts with receiving a complaint. So this is usually where we receive written complaints, where you dictate all of the information that has led you to file the complaint. So once a complaint is received, an investigator is appointed. So depending on the situation, it can be an internal or an external investigator that is appointed. So usually it's recommended that for when we're looking or appointing an internal investigator, they're usually selected when the complaint is less serious, there is a single incident, and issues are clear, whereas external investigators are usually appointed when there are serious allegations. It involves a complaint against management. There are multiple incidences. The HR personnel is a little too close to the investigation. There are any PR issues, so public relations issues. The police are involved, or it is ordered under the Ministry of Labor. So your organization will determine whether they seek an internal or an external investigator. And usually these are the guidelines provided under OSHA for what they should look at in terms of who they should appoint for that investigation. After the investigation, the investigator is appointed, the investigator will actually reach out and contact the parties to advise that investigation is occurring. Usually that's the complainant, who is the person who's filing the complaint, and to the respondent. So that is the person who the allegations are being made against. So they will reach out to both and let them know that an investigation is occurring. In terms of interim steps, these are usually taken if required. And depending on the situation, the employer may decide to provide both parties with a leave of absence with pay, but it's not a requirement. The only thing that we do provide as a guidance is that the employer should not take any steps in advance of the investigation. So there should not be a suspension to either party, and no one should be terminated in advance, because an investigation does need to be conducted before a decision is made on whether the harassment is actually occurred or that we can find based on the information that we have. So after any interim steps are concluded, if you are a complainant, it is that you should be aware that all of the allegations that you bring forth will be provided to the respondent. Now, in the process, it is important that every party has the ability to know what is being said and that they can respond to that and provide information. Again, this is a little different than if we're looking at it in criminal law. It is employment law. So when you're conducting a workplace investigation, we're looking at it in a different sense of determining whether the allegation occurred or not. So it is a different set of standards that are applied to determine that. So the respondent does get a copy of the allegations and they are able to respond to that. That occurs in the interview process. So the investigator will conduct interviews with the complainant and with the respondent, as well as any other witnesses that are brought forth or identified by the complainant and the respondent. These interviews are important, and they need to be conducted in a place that is safe for both the complainant and the respondent. So they shouldn't be happening in a workplace out in the open. It's very important that all of these interviews and the whole entire process is confidential. And additionally, you won't be interviewed at the same time as the respondent, so the interviews are separate. So that's important as well. And then once all the information is collected from the interviews, from any documentation, then the investigator will look at all of that information and determine the findings and prepare a report.
Can I ask a clarifying question? So we're saying the person who's filing this complaint, bless you, who's filing this complaint, the information they're providing in their interview is not, it will be provided to the employer, right?
So the interview, actually everything provided in the interview is reviewed in a statement. So the investigator will type up a statement that is then showed to the complainant and the respondent, and they sign off that they have approved that. So you don't actually get a copy of it, but you are provided the ability to reread everything that the investigator has taken down during that interview. You can sign off that you agree with everything in that, and you can actually make changes to it as well. But that is kept confidential. It does not get sent to your employer.
Okay.
So just to be clear, the only thing that will be sent to the employer at the end is a full copy of the report from the investigator. And the investigator will provide you with a summary of their findings, as well if the harassment is deemed that it did occur, as well as a corrective actions that will be taken.
Okay.
Yes.
I think the important part too is if I have a complaint against a colleague,
Mhm.
is I mean, I can say, oh, so-and-so is mean to me, but the important thing is to always have examples
Yes.
of your
Mhm.
comments and be sure to include on, July 4th, at 1800 hours, Jessica hit me, or you know what I mean?
Yeah,
Like
yeah.
Yes.
that's important you can make all kinds of claims, but you've got to have the evidence, you have to have the proof of what that person did to you. And I mean, I've been through the process, and I think the
Mm.
most intimidating part of it as well is you're already feeling bullied and intimidated, you guys. But then when you actually write down all the things with the examples, with the evidence, and then I know that I'm handing it over to this person that's been bullying me or intimidating me, it's very, I don't know how to explain it, but it's really gives you bad feelings.
Yeah.
Yeah, unfortunately, we do hope that in most organizations, they do have somebody else that they can go to, but that's not always the case. We 100% realize that.
Mm,
And that's why you can bring it up to somebody at legal aid, and they can start the process as well to get an
Mhm.
investigation occurring. So if you are under that situation where you feel a little uneasy to submit a complaint to your organization, you can go speak to legal aid and they can
Mhm.
assist as well. So it is key. Details are key. So I will explain a little bit of the investigator's responsibilities, but it's good to know that any investigator can only look at what they have in front of them.
Mhm.
They can only look at the information you provide, the information the respondent provides, and the information any witnesses provide. So it is important to be very detailed. So as you were saying, having key specific dates, comments, etc., will help an investigator determine
Mhm.
whether or not something occurred based on all the information that they are provided.
And it's hard, right, to keep all these things in your mind when you're going
Yeah.
through this really difficult process of experiencing workplace harassment, right?
Right.
But what we're saying is that as best as you can, try to keep these details in your mind, because those will help your case. Document.
Yeah.
Somebody hit you.
Absolutely. Yeah, if it's an assault, like you're right. Like if we're talking about something criminal, there's no advice I'm not giving you advice on what to do or what not to do.
Yeah.
But yeah, if things are escalating into violence, that does actually trigger the criminal law procedures as well as the workplace procedures, right?
I just use that as. Yeah, I mean, because, so.
And I saw you put the nice armor on you to say, I would never do that. Go ahead. I think.
So in terms of an investigator's responsibility, it's key to note that we are there for fact finding only. So we're trying to determine, did it occur? So we have to determine based on the information that we have, but it is important to note that the entire process during the entire process, that an investigator is supposed to act ethically with honesty and integrity. They're supposed to be a neutral, impartial party.
Mm.
So they can't come into it with preconceived notions of what occurred. We're only looking at the facts based on the information that we're provided.
Mm.
So we need to be competent in our ability to read and all of your statements, to listen to the information that you're providing, and to review the evidence as well. We have to remain unbiased throughout the entirety of the process, and we are just curious to determine what did occur. So that's looking at, again, all the information that we have. It's important that we treat all employees and any union members that do attend with you. So as an employee, you do have the right to have a union representative during your interviews. You can have a support person. You can have a translator. as well. So we want to make sure that the process is equal for you as it is for somebody else. So if you need somebody there to support you or to translate for you, you are allowed. The key thing to remember though is that those people are there to support you. They are not there to speak on your behalf. We do need to hear it from you as the complainant. Again, if it's a translator, it's a little different. They can speak and translate for you, but it is important that you are speaking and you are indicating what occurred. So it's also important the investigator follows their process. So they will outline an investigation plan, and that's how the process will be conducted. And we want to look at to ensure that also the organization's policies are followed. So if they have a harassment policy, we're looking at that to make sure that the person who is complaining against somebody, that we're looking to determine if the policies were followed correctly, if they broke any of those policies, and also looking at how the investigation was conducted as well to determine from the start of your complaint if the process was handled appropriately. The main thing that we need to always remind the complainant and the respondent about is confidentiality. So as I said, we will do our absolute best as an investigator to make sure that the entire process is confidential, and we expect the same from the complainant, the respondent, and the witnesses. So every time that you're in an investigation, the confidentiality process and policies will be explained to you. So we're not going to be sharing your interview notes with the respondent. Again, it is your original complaint that is shared with the respondent. But we're not going to be giving what the witnesses said to the respondent or to the complainant, etc. So the process is confidential throughout the entire thing. So in terms of investigation findings, as I said, it is different than a criminal investigation. So the findings are tested against a balance of probabilities. So we're trying to determine what is the likelihood that this event did occur to a reasonable person. So it is a little bit of a difference. We're not looking at beyond a reasonable doubt. We're looking at the balance of probability. So what was the most likely event that occurred? And that's based on the information that we have to look at.
Has anybody heard of that phrase, reasonable doubt? Like beyond a reasonable doubt? So in criminal law, when you have to prove something, it has to be proven beyond a reasonable doubt, right? So it can't just be like, oh, we believe this happened or it is likely that this crime occurred. It has to be a higher standard beyond a reasonable doubt. So there can be no reasonable doubt that it happened. Here, we're looking at a lower standard. So it's a balance of probabilities. Did this happen? And
Likely occur, yeah.
did it likely occur is the language. So you see, that's a bit of a lower standard than the higher standard of reasonable doubt.
So we can only determine, because we're an investigator, we're looking at the facts and we're there to find the facts. We are looking at what most likely occurred based on the information that we actually have to look at. And that's where the comment about being super detailed does help us, because we're actually able to look at all the information that you have provided that demonstrates a greater likelihood that the event occurred. So another key thing to note is that the entire report, as I said, is submitted to the organization only. You get a copy of the summary of the findings and any corrective actions that are going to be taken against the respondent if the findings determine that the harassment did occur. An investigation by the OSHA is to be completed within 90 calendar days. There is some extenuating circumstances that can push an investigation to be longer. For example, someone is on leave, so we can't actually interview them, which does essentially push out an investigation, but we try to complete an investigation within that 90 calendar days. And the best code of practice is to have the investigation report within 10 calendar days of completing the investigation. So those are kind of some timelines that you guys should be aware of. An investigation is a lengthy process. We do have to interview as many people that would have witnessed the harassment occur, as well as the the complainant respondents, and sometimes these interviews are quite lengthy as well. And just on that note as well, the investigator is not responsible for determining any disciplinary actions. We can provide guidance saying that these actions warrant certain corrective actions or disciplinary actions, but we're not responsible for determining what the organization is going to take in terms of corrective actions or disciplinary actions. So in terms of best practices for conducting an investigation, it's important to make sure that it's fair and objective. So an investigator must be a neutral, impartial person who can assess and gather facts without any preconceived notions or assumptions. So it's important that we are looking at everything coming into it from a very neutral and objective stance. So we don't have any preconceived notions about anything that has occurred. It's also important that when we're discussing or conducting an investigation, that we are using terminology that's specific to the industry or relevant to the organization, employees, and employers, so that we are making sure that you understand what has been going on or what type of situation has occurred in a specific area, etc. So we want to make sure that the terminology is representative of your organization as well. Additionally, we're always to conduct an investigation by being professional and empathetic. So we want to make sure that we understand your position, but we're not coming from a point of sympathy. We're not here to make a preconceived notion during the interviews. We're here to be empathetic so that you feel confident enough to open up about the situation. Harassment can be really tough. As I said, there's multiple types of harassment, and depending on the instance of harassment that you're experiencing, it can be very, very tough to speak about it. And you want to ensure that the investigator that you're working with is empathetic and can conduct the interview that allows you to feel comfortable to open up.
Is there something you can do if you don't feel like the investigator is behaving in that way?
So you can talk to your organization, especially if it's an internal or external investigator. Depending on the size of the organization, an internal investigator, there might only be a few. Again, if the report comes out and you're still unhappy, you can go and speak to legal aid for a lawyer representative. But the investigator is kind of your first line that conducts the investigation. And again, if you have any concerns about the investigator, you should bring it up with your organization, and a new one could be appointed depending on the situation.
Can you stop it right from the beginning then? Like, so you show up to be investigated and you say it's, the manager, your manager, or it's somebody that's familiar with the person you got the complaint against? Can you just say, wow, wait a minute, I'm not comfortable with this off the bat?
Yes, you can say that you're uncomfortable with it. Again, like I said, it depends on the organization and who they have available to be the internal investigator. But if you do feel that there is bias at any point, again, I would recommend that you seek legal advice in that sense, just to get that separation. That's just the best practice. Again, I can't provide legal advice to you today, but that would be the situation that you would do if you were very uncomfortable or felt as though there was any bias that could impact your investigation.
So it makes sense that this is your first line. This is the most available, like this, your investigator should be behaving this way. In fact, we have all these standards that dictate how they should behave, but at any time you can go the legal aid route and talk to a lawyer to guarantee that you're actually having that distance, right? Okay.
And as I said, like, confidentiality is to be maintained at all points. So your investigator will bring that up with you. Normally there is some type of confidentiality statement to be signed, but it's very important that you are aware and that you follow the confidentiality policies. Additionally, sometimes there is reluctant complainants or witnesses. And it's important that if you feel uncomfortable to discuss anything about your complaint, that you try and push through that, because we can only look at the information that is available to us. So we really do encourage honesty throughout the entire process, because as I said, we're there to fact find, and we can only do that with the information that's provided to us. So that's something to be aware of when you're in the process. And additionally, documentation and evidence does help to support your claims. So if you have any evidence or documentation available to you, it's important that you bring them to the meeting and to your interview so that the investigator can look at all the information that you have available. So what is required of your business? So your organization should have the appropriate policies in place. So they should have a workplace harassment policy that sets out how incidents or complaints of workplace harassment will be investigated and dealt with, how to report a complaint as well. There is cases where sometimes anonymous complaints cannot be investigated because we don't have the information or the nature of the investigation, the amount of information needed to move forward with that. So it is important that if you can try not to submit the complaint anonymously, some organizations will have additional tools, like a support line that maybe can track and reply to the individual to get more information. But unfortunately, sometimes in an investigation, if it's an anonymous complaint, we can't fully investigate the information because we can't go back to the person and ask additional information.
Yeah. So
it is the best policy to submit the complaint not anonymously. We understand that sometimes that situation doesn't happen. So you might be prompted for additional information if that's a possibility, but we can really only go with the information that we have, and we do have to interview you. So
To go, but is it possible for to get a copy of the presentation?
yeah,
That's fine with
should
me.
be- yeah, that should be fine. It's also, we're actually taping this right now. So it will be available on the Law Society website as well. Perfect.
Thanks for coming.
Thank you so much. Yeah, I'm just, I only have a couple more points. That's the last slide. So, additionally, the policy should be reviewed annually and updated accordingly. And your employee must train you on the policy and program so that you're aware of how to report, what steps we'll be taking, how an investigation will be conducted as well.
So
this-
if you forget everything from this presentation, they actually have an obligation to take you through that.
Yes.
Okay.
So we just included some resources here that you can reach out to if you have any questions. So Legal Aid Nunavut, there is the lawyer referral service on the Law Society website as well. There's also a legal knowledge section and the Labor Standards Board. Oh,
Yeah, let's just leave that
There
up.
if you have any questions at all, we would be happy to answer them. You can reach out to the Law Society. You can also reach out to Legal Aid, and we would be happy to put you in the right direction, or give you information for the right person to speak with if you have any questions.
Great. So thanks everybody for coming. That concludes today's presentation.